I just thought I'd start with a little story about a family dynamic. We had a client that had, he was the last remaining spouse. He had $400,000 in his RIF, and he named all 4 kids beneficiaries of his RIF to bypass probate. His 4 kids, one of them was a doctor, one of them was in jail, the other one was divorced and had no money, and the other one made a low income. So $100,000 gets sent to all 4 kids. The doctor's son was the executor. This is the only money they had. So now you've dispersed all the money to your 4 kids. The executor has no money, and he has to pay tax on the $400,000. So the person, the executor now has to pay, call it $180,000 to the government. If he doesn't have it, he has to go to his 3 siblings. In this case, all 3 siblings had no money left. So he doesn't send all the money in, and everyone thinks the government's going to come back and go, I need 25% from each of the kids. No. They go to one person. And they tend to go to the person that actually has the money. In this case, our client had to pay the full amount of tax for his dad because of how we set up beneficiaries. It's a really easy thing to do if your family gets along, they all have relatively the same income. It becomes really easy to pick beneficiaries. But when you have a family dynamic that's different, it's really important to make sure that this says estate. So when we talk about estate planning and where your beneficiaries should go, does your executor have money to pay out, depending on how many accounts you have? And if the executor doesn't have money, then we move this to estate. Now it gets into the 1.5% probate tax. But you're guaranteeing the executor that has cash. Sometimes we have 2 kids or 3 kids and they're different income levels. The other thing that's important to know when we're picking executors or powers of attorney, we see a lot of the times everyone wants every one of their kids on it. Well, hopefully they all live in town and don't live out of the country or out of the province, because they all have to sign things. And it's important that you pick the right person, the one you trust, when you pick your executor and or power of attorney, but make sure they do not live outside the province or outside the country. And this is why we have to change things, because our kids tend to travel around and move and do things like that. So it's important to keep them up to date. We talked about how we avoid probate, but does anyone have any questions about executor and power of attorney? And who to pick?
Can they decline?
Yes, they can.
Because, I mean, I've seen it happen where someone has been asked to do that or written down, but it actually would be such a stress or other circumstances come in.
Yeah, it's important to kind of let your executor know that they are the executor of your will, and let them kind of feel them out. I don't know if anyone's been an executor, but it is a lot of work. And it's really important that you do pick someone. We have a company on site as well. You can get outside counsel to be executor, where they take a 4% fee. But in theory, an executor, even though their family, can also take that 4% fee and pay themselves as well. But the more complicated it gets, it's probably not a bad idea to make sure you're having that discussion with the executor. Just on that note, I brought some booklets that we hand out to our clients, and it's just called estate planning. And in this booklet, it kind of tells your executor where everything is. Who's your lawyer? Who's your bank? Where's your money? Where's your life insurance? Who do you want contacted when you die? You don't have to put amounts in here, but you can put account numbers in and who you're dealing with. It just allows the executor to know where everything is, because as Ted has probably alluded to, we've had people die and you can't find the will, right? I don't know how many people I've talked to that wanted to be cremated and the kids didn't know it, and they buried them in a casket. So, because they couldn't find the will. So, you know, it's important to make sure that you're upfront with whoever your executor is. Sometimes that's difficult because it's tough to change executors if you pick one, right? Because now you got to go back and say, yeah, you're not going to do it. I got somebody else, right? Uncomfortable, right? Powers of attorney are very important, as Ted alluded to. But the biggest thing is we talk about, should I add my kids, Hart, to your question, should I add my kids to a joint bank account? We're seeing that more and more now, just because a lot of people don't have powers of attorney set up. It's a little easier now because in theory, you could, if you have online banking, you could give them your password. So the bank really doesn't know that that's happening, but it's important to probably have 20 to 25,000 in a joint account with one of your kids that you trust. So if something did happen to you, they have some cash to pay. Unfortunately, my father-in-law died in October, and my Lisa's stepmom has dementia, which we just found out while he was sick in the hospital. And now when it came to paying the funeral home, we couldn't tap into it. We had powers of attorney set up, but they take time. So we went to the banks and said, here's the power of attorney, but has to go to their legal department. It takes a couple weeks to kind of get set up. And it is not the easiest thing being power of attorney too. If a doctor hasn't signed off to say you're incapacitated, which we're having the problem with Ellie being, having dementia.
If I can just add to that, what we often tell people when we're making powers of attorney for them is that these powers of attorney are good for most things, but the banks, if you've got accounts at a chartered bank, they always have their own procedures. And it's best to go to the bank and fill out their forms if you want a child to be a power of attorney on a particular account. Fill out their forms now as well. Don't just count on this power of attorney we did for you, because dealing with banks, those are huge bureaucracies, and they're very, very slow at processing things. And so, that's one extra step you can do. When you yes, get your power of attorney properly done at a lawyer's office to cover other things, but for bank accounts in particular, you go to the bank and get the person that you want as your power of attorney signed on ahead of time, and then that'll solve that problem.
Yeah.
Let me just make it, so we have just given our daughter, put her on our bank account. So whatever is in the bank account, she has access to. She's also has power of attorney, and she is executor. Okay? So if something happens to us, there should be no issue with the...
Well, yeah, in theory, yes. We always... you have to make your intentions clear. When you, as far as the power of attorney and so on is concerned, that should all be straightforward. But when you put a child on a bank account as a joint owner, remember what we talked about, the law of survivorship? The normal rule is that the survivor is the sole owner. You die, and now the surviving joint owner owns that account. It's theirs. And there's been a lot of litigation in Canada over the years about that, because of parents taking one child and putting that child's name on a bank account as a joint owner, and then later on, when the parent is gone, that child says, well, that's my money, that's not part of the estate because I'm a joint owner and it just came to me. And the other children saying, wait a minute, Mom and Dad, you were supposed to be holding that for all of us.
It's not going to happen.
Well, no, I know, but it's not going to happen in your case, in your family, but it has happened many times in many families, which is why as lawyers, we always warn about the risk.
But there are also tax benefits, right?
The only tax benefit is that 1.5%.
Yeah, okay.
And, and so the question is, are you worried about the small tax, that 1.5%, and potentially, in some family dynamics, risking a situation where now you've caused a war between the children, and you've spent tens of thousands of dollars, they've spent tens of thousands, you're gone, so you don't care, but they've spent ten thousands of dollars in legal fees fighting over whose bank account. That's why we're always cautious about, if you want to put a child on an account, just make sure the intentions are clear. There's a Supreme Court of Canada case about this very situation. If you want to look it up, it's the PECOR decision, P-E-C-O-R-E. The Supreme Court of Canada, that's 20 years or so ago. And in the PECOR decision, the Supreme Court of Canada said that if an elderly parent puts assets into the name of a child as a joint owner, the presumption is that asset is held by the child for the benefit of the estate. But it's a rebuttable presumption. So you can have, you know, we start with, the presumption is that the parent intended that this was for the estate. But if there is sufficient evidence that no, the parent intended that that was for that child, and it wasn't for the estate, then that presumption can be rebutted. And so we get into this issue with kids, you know, or parents who are asking us, should I put my house in joint names, or should I, with one of my children, should I do this or do that in joint names? And so we bring them back to, well, what's your intention? You know, let's talk about what your intention is when you die. Is this just going to that child, or is this for the estate? And then we usually get them to document something and put something on paper about what their intention is when they're doing that. And that's how you address that issue.
And just to go back to the, should I put my kids on title of the home? Imagine you did this in 2019, before the boom. So now, when you die, the home right now currently is principal residence, there is no tax. But when you add a joint person and say your kids own a home, well now half of that money, that growth, is a capital gain to them, because you can't have two principal residences. So that's where it really becomes difficult, depending on how long you're gonna live, but really their half has to be taxed to them because it's their second home.
Yeah. That's absolutely correct. We have done some workarounds sometimes by getting a trust agreement signed, where the idea is, you know, we put it right on paper that the child is holding their half share in trust for the parent, and they're not really the beneficial owner, to try to address that tax problem that Brad has quite correctly mentioned. But yeah, there's a lot of stuff to think about when you do these things, and it's not just as simple as, oh, I'll put my child as a joint owner and everything will be fine, you know, all to save that 1.5%. Yeah.
And I think that's kind of what I had. Does anyone have any other questions that they'd like to ask either of us?
I have another question for Ted. So, okay, you have a child that you've been helping out exceptionally.
Yes.
Up to a certain point. At what point can they say, you owe me?
Oh, it depends.
Let's say, okay, a year or 2 years have passed before you pass away, and you haven't been helping the child anymore. You said, that's enough, or we're done.
Yes. Well, it always, the classic lawyer's answer, it all depends. But generally speaking, if there's evidence that that dependency relationship was terminated and finished before the person died, then that's a very strong piece of evidence that that person is no longer financially dependent. But if that was still going on right up to the person's death,
Yeah.
you know, then
Okay,
yeah.
that answers it, yeah.
In addition to that, like, how does that get proven?
Yes, that's what I want to know. How do you prove that?
Well, typically what happens is that the person, the child or other, you know, person who is claiming that they were financially dependent comes to a lawyer's office and said, you know, my parent just died and they were paying my rent every month, you know, and so on. Okay, show us. You know, and we look for bank records and find, you know, and typically the way this is handled in the legal system is that that person brings an application to the court against the estate. We call it a dependence relief application, under the Succession Law Reform Act, and that in the estate then has to respond to that, and financial records get produced, you know, and all of the documents are about, you know, flow of money. You know, usually there's a record of, you know, every month you can see there's a check that went or something like that, you know. So that's how you prove it. It's literally documentation. It's based on documents. Yes.
I've got another part of that, because I have a child who had needed much more support than my other kids, and I've actually been keeping track of that and assuming that that would come out of inheritance.
Oh, you can't assume that.
Can't assume, no,
No,
so that's why I
yeah.
didn't get that in right.
Yeah, I mean, if your intention is that is so if you have allowed a dependency relationship to exist and be created, the fact that you think, well, I've kept track of that and I'm gonna take it out of that person's share, well, that may be what you wanted or what you thought, but it's not a given that that's what the end result would be. Because once you've allowed that person to become dependent, there's a potentially an obligation to keep on making sure they've got enough money after you're gone. And simply dividing the estate equally doesn't necessarily meet that obligation. Our courts refer to legal obligations versus moral obligations. We use, that language is used in the cases. And typically our courts try to balance this. They sort of say, well, you know, this deceased person had a moral obligation to leave their estate, you know, to all of their children and their beneficiaries, whoever, but they've got a legal obligation to this person who they were supporting. And to be fair to everybody, how do we balance that? Nobody gets everything that they want, typically, you know, because there's usually not enough to go around. And we end up kind of reaching compromises. Yeah.
Yeah.
That's why, as lawyers, you know, I have to say, life is never black and white. I mostly wear gray, because that's the color I work in mostly, you know. There's very little black and white in the law.
Living color.
Sorry, there was another question, again.
I just wondered if it applies the same, should a child be added to your home? Does it apply the same to a cottage?
Sure.
Like, it would work down that it's not principal residence.
Right.
So how
Yeah,
does that work?
so to add a child to a cottage or a home, now you're making it, you're actually selling the home and now
Yeah.
both of you are owning it, so you gotta pay the capital gains tax to add them?
That's a deemed disposition,
Yeah.
because it's a non-arm's length transaction, so it's a deemed, the minute you put your child on your cottage, because it's a capital asset that is normally taxable,
Okay.
the minute you put your child's name on the cottage, you have created a deemed sale of that half share to that child, and you've triggered a capital gains tax for yourself. So people try to, you know, you usually get advice before you do that.
So you pay the tax and then they would own half.
You pay the tax and they would own half, but what happens when you die?
Your half would be sold to as the estate asset,
Yeah.
and you would pay the capital gains on your half.
Their half has already been taxed, basically. 'Cause
So is it better to hold that cottage and put it in the will than to put somebody's name?
What's the purpose of putting, you want it to stay in the family, right?
Well, that's the idea.
Yeah, so the question is what's the tax liability by making that, trying to keep it in the family? So
Yeah, like, is it better to put somebody's name on it or put it in the will?
it all depends if you have enough money to pay the capital gains now.
Yeah, the tax is gonna be paid sooner or later. If it's a cottage, by definition, there is going to be tax.
Right.
You know, and the question, if you put it in the child's name now, you pay the tax now. If, you know, or at least the proportion, or if you wait till you die, then the estate pays the tax. But one way or another, it's all a question of when do you wanna pay the tax? And do you have the funds to pay the tax now? If you can't pay the tax, don't put it in your child's name.
That's right. And that's typically why we see cottages being sold, is that the kids can't afford the capital gains tax
Yep.
to keep it when you do pass away. So that is a difficulty. How we try to cover that off is with life insurance, right? So that's a planning tool that we use to say, if you want to keep this in the family, let's take out life insurance on and project what the capital gain could look like in 20 years from now or 30 years from now. And then they have a beneficiary, which are the two kids, they can pay the capital gains tax and keep the cottage in the family. So life insurance is a wonderful thing, I just hate the word. Yes?
If you have a life lease and then you die, what happens? I mean, I'm not even sure I understand what a life lease is, but my mother's in a retirement home where that's the situation.
Yeah. Most life lease contracts provide, you know, you've paid a lump sum, and usually a portion of that, maybe it's not 100%, but some portion of that will be paid back to the estate of the deceased person. And because that's a principal residence, that's a tax-free transaction. Like typically people sold their home,
Okay.
which was a principal residence, and they took the money from their home and they invested some or all of it into a life lease. And then when they die, they'll get some of that money back and it'll go to their estate. Ordinarily, that would be non-taxable because it's still a principal
So it's
residence.
just a simple,
That one should be fairly simple, yeah.
And so something like, you know about Parkwood,
Yeah.
and is it life lease or is it?
It's right.
Well, Parkwood has the nursing home and the retirement residence,
But-
but there's those garden homes.
The garden homes, yeah.
I'd have to talk to my wife to be sure. I believe that was it wasn't actually a life lease, it was some, I'm not sure exactly.
Permission to live or something.
Yeah, there's some kind of arrangement there, but they get their money back.
Yeah.
And because it's a principal
So it works
residence.
the same.
Yeah, it works the same, I believe. Yeah, I don't think there should be a tax consequence there, unless they had another residence that they were calling their principal residence.
Okay, last question.
oh, shucks.
Over here.
Sure.
Yes, I just wondered again, you mentioned something about a low income tax. One of the,
The GIS, the threshold of low income.
what kind of qualifications must we have? My sister lost everything through a fire a year ago, and she's really going through tough times, and she is basically the mother, the grandmother, she pays for everything, there's no father there, my sister, her husband died, so it's very complicated, and we do help her out, but, you know, we'd like to know if there's something like this, what the qualifications would be that she might be able to apply.
Yeah, I can get that information for you,
That'd be very
the
helpful.
application. It's called a GIS application, like I said, hopefully next year they won't have to. And you get to subtract old age security from your total income, and that's how they determine it. It's all based on how much income you make and how much extra they'll give you.
Well, she is retired, but, has been alone for a number of years.
And is she over 65?
Yes.
Yeah, okay, yeah, because you have to be over 65.
Brian,
Yes,
sorry to interrupt you, but if you buy those income tax programs like I do,
yes,
and put them in your computer, it's TurboTax or something.
TurboTax, yeah.
Yeah. For the last 3 years, it's automatically put the GIS in.
Oh, good.
The program has.
Has done that, that's
Yeah,
excellent.
because I started, all of a sudden I started getting it.
Right,
Why am I getting this money? And when I inquired, it was GIS.
yeah, good.
And it did it automatically.
Yeah, so a lot of the new programs are really good that way. Yeah, no question. Yeah,